Wonderful, everybody. Thank you so much for joining us today to discuss Wills Week and wills. I've been so looking forward to this segment all week. And part of it is because I get so many questions from you guys about wills and, how complicated it is. And sometimes, it's just simply not always, as simple as we think it is. But also, I think a lot of us are worried about the cost of doing a will and how do we do a will. But if we just realize that spending a little bit of time, even a little bit of money right now is going to save us a huge amount of money later. So I am joined today by David Thompson and Moremadi Mabule from Sanlam Trust. And they are here to help me answer all the questions that I've been getting from you guys. So welcome, David and Moremadi. Thank you so much for spending this time with us.
Thank you, Maya.
And I know David was telling me he was on a discussion this morning on Zoom with his staff, with just the internal staff at Sanlam about wills. So even the people at Sanlam want to know about wills. So I think this is a really, really, really important topic. But I want to start off with why a will is important, because I think it actually shocks me that so many people, 75% of people in South Africa don't have a will, and the people that I come across who don't have wills have assets and they have children and they have all these things, but they've just never got round to writing up a will. Now, Moremadi, you and I were chatting and you told me a very interesting story about a guy called Ed that you've come across who died interstate without a will. So maybe I think that's a great perhaps starting point to explain what happens when you die without a will.
Yeah. Thanks, Maya. Thanks for the invite. And, I just want to share around there's lots of myths around wills itself. Like you said, there's a lot of people who actually have assets but they don't get down to doing it. And it could be people are procrastinating, or people feel, this is not for me, or I will be gone anyway. People will worry about it. But I think I just want to also emphasize what is the importance of actually drawing up a will. So in South Africa, we've got what we call freedom of testation, which is a right that everybody has, anybody who's above the age of 16 has, to actually go sit down and draw up a will and decide in terms of who needs to inherit out of their estate. So that opportunity of sitting down and drawing up a will gives you an opportunity to choose who's going to be the executor of your estate, who's going to benefit from your estate, and who's going to be a trustee, and you get to nominate a guardian of your minor children. However, if you pass away dying intestate without a will, we've got the laws of interstate succession, and they actually dictate what needs to happen when you pass away without a will. And I'll briefly explain what law of interstate succession actually says. It says when you pass away, it looks what we call next of kin, in inverted commas, we can look at bloodline. And that actually dictates who's going to inherit. If you are married with children, depending on your marital regime, it will go first, the portion that goes in terms of the marital regime will go to the spouse, and your share will go to the spouse and to the children. And if there is no children, it will just go to the spouse. If there's no children and there's no spouse, it will go to your parents. Failing parents, it will go to brothers and sisters. Failing that, it will go to cousins. So it looks at bloodline with two exceptions. The two exceptions that people that are likely to inherit without being blood relations would be your spouse and would be adopted children. And there's always interesting dynamics around interstate succession, and that's why it's important. If you want anybody to actually get out of your will, out of your estate, you'd rather put it in writing.
But Moremadi, you talked about, the wife gets, or the spouse gets something, the kids get something. To me, it sounds like, well, that's okay. That's what I want to happen. But in Ed's case, as we were talking before, it kind of was that, when you die, that doesn't necessarily mean what you actually want to happen. Because that, I think, to me, interstate sometimes feels like, I'll just leave it and it'll work out the way I want it to. Maybe, David, do you want to comment?
Yes, the problem in this case of this particular gentleman is that he was married in community of property and owned a house. And yes, in terms of the community of property marriage, the surviving spouse, in this case the wife, would obviously be entitled to 50% of the house as part of the joint estate. The balance of the estate would then be split, and she would get a child share out of his half share, and the rest of the estate is shared amongst the children. The big problem is that she can't afford to maintain the house. There's a bond, she's not employed, so she would want to sell the house, but she can't, because the property is now going to be transferred in the name of minor children. They would now have to approach the High Court to get permission to sell the property. And I know from experience that permission is very, very difficult to achieve, and it's costly. So just simply doing a will, leaving the house to her, could have saved her a lot of hassle. Now she's lost her husband in a terrible accident, no will, there's total confusion, and she's in a terrible state. And the law can only help her so far. The Interstate Succession Act is there, but it doesn't take you all the way.
Absolutely.
Yeah, and also, so now you've got this will, and maybe you've written one up because you've been listening to this, but it's also important to make sure somebody knows where this will is. I mean, didn't you also wrap up an estate where it was all wrapped up and somebody produced a will that came in later?
Yes. No, absolutely. Our estates department was quite far advanced with an estate, ready to distribute. In fact, have distributed some of the assets already. And then the family, through an attorney, have somehow procured a will which they claim is valid and is dated at a later date than the will that was originally accepted by the court. So, if there's any dispute with some of the heirs in terms of the previous will, which we thought was the final will, might well oppose the later will and say that they have some evidence possibly that the testator wasn't of sound mind. So, the parties may have to end up going to court now to prove which is the valid will. Even if the second will, if it is declared valid, then we've got to unwind the distribution of an estate, which is very, very expensive. It could be. And also, what if some of the properties have already been transferred to people? How do you get them back? Not easy.
I tell you, I think your guys' jobs can be very complicated. We don't know that. So I've got a question in here that I want to ask, and I think this is a very good question. Maybe, Moremadi, this is one for you. So this man writes, with so many people in this country not necessarily rich, why are wills shrouded in mystery? Why are there no simple examples that people can just fill in and have the dignity of a valid will without paying a lawyer or a bank? Now, I found that interesting because I know how many free wills there are, and I think Sanlam has one online that is free. Moremadi, maybe you want to talk a little bit about, do you think there is enough access to wills, or do you think just not an understanding that they of where to get them?
I think, Maya, my experience has been we need to continue educating people, because people assume that wills are for the wealthy. And because they are for the wealthy, it's a costly exercise. And there is so much material that is available that wills are actually drafted for free. I mean, I'll give you an example with us. Online, you can get a free will. Even when you want a comprehensive, a very comprehensive, detailed will, completing an application form and sending it through to us, it's not going to cost you an arm and a leg. We actually draw it up for free. So there is, this misperception that because, we're dealing with assets and it means you are wealthy when you want to preserve them, then they assume it's a costly exercise. It's not costly at all.
Well, I mean, I think even at most, I've never seen a will for more than 500 Rand. But I suppose that's writing up the will. David, when should you get perhaps more advice than that? I mean, is there a whole financial planning element in that? Like, what advice could you expect to get when you're drawing up a will, or should be getting when you draw up a will?
Yes, it's an interesting question, because if so many people die without a will, and even that Bank of America Merrill Lynch survey, which was done, I think it was something like more than 55% of people in the state over 55. There was a survey done, don't have a will. It means that the current paradigm of doing a will worldwide is somehow not working. And though we might say on the one hand it's simple, on the other hand it isn't. And that's where holistic financial planning is so important. And yes, Maya, it is really important to engage with a skilled financial planner professional. When you need to do it, it's really up to you. You could populate an online will through a company like Sanlam. It's proper. It's going to be quality controlled. It's going to be checked. you can then store the will with us, and then we'll charge you an annual safe custody fee of 50 Rand plus VAT, which is very, very small. But generally, basically, the will is drafted by people who are well qualified. Yet people still shy away from it. And I think Moremadi is quite right. It's an education. We need to actually start with children at school and at universities as to when you need to cross. I think that, look, if you are potentially going to be exposed to estate duty, so you've got an estate of over 3.5 million net, and that would include the proceeds of life insurance policies, I think you should try and engage with a financial advisor. But there's no harm in at least getting a basic will done now that suits your needs, so that you know, okay, I've left my estate at least to my children or to my spouse, failing whom to my children. That's in place. Now I need to engage with a financial planner to say, okay, what are the implications, executors' fees, estate duty? How can I plan my affairs a bit better? But to just leave it completely, you know, for example, no one buys a car and never has it serviced in 5, 6, 7, 8, 9, 10 years. Well, very few people do, because it'll just stop running. At some stage, unfortunately, we also stop running. We think we're invincible, but we definitely need to get a will in place. And getting a simple will done is a very, very good start. And that there's no harm in that. There's no prejudice. You know, that when the master looks at the will, he's not impressed whether it's 20 pages or 2 pages, as long as it's valid and it can still work.
And you mentioned there leaving, you know, possibly if you want to leave money to your children. So, you know, for example, for my husband and I my will set up that he just inherits everything. It's much cheaper. There's no state duties payable. Yes. But, you know, if something happens to both of us at the same time, then we have a testamentary trust set up. So maybe because I think that's quite a lot of people don't realize about how they can protect their children within their will. Who wants to pick that one up? Moremadi?
I'll take that one, and David will add on if I miss something. So, you know, I'm very passionate about testamentary trust. And I think even this morning I mentioned at length that we do spend, you know, in the will itself. I mean, we took a business decision that all our wills where there's minor beneficiaries, we're going to put a clause incorporating a testamentary trust. But I want to explain to people that, you know, a testamentary trust would mean absolutely nothing if you don't ensure that there is enough liquidity in that estate. I'll give you an example, Maya. As I'm sitting here, I'm a mother. I've got small children. I am the one that is putting bread on the table while I'm still alive because I'm getting an income. And when I pass away, that lifestyle must still somehow continue. How do you make sure that it continues? It's by making sure that you leave enough cash in the estate. A lot of times we do get, you know, a lot of unfortunate situations where people have bonds, they didn't take credit life, and they pass away. Now, all of a sudden, this money is due and payable. We've got minor beneficiaries, but you've got zero in the estate cash-wise. And that could be a very costly exercise. So a testamentary trust is a good vehicle for protecting minor beneficiaries. You can keep it in trust and terminate the trust at whatever age that you choose and you see fit. I mean, a lot of times, most of the clients, they actually select that they terminate the trust at the age of 25. At the age of 25, comfortably, you can say your children, you know, they probably have a degree, they're self-sufficient, and they can get the capital. But what happens between whatever, let's say when you pass away, those children are still at the age of 6, for argument's sake. Between the age of 6 and 18, the trustees will actually make sure that they pay the income to the guardian who's going to be looking after those children. From the age of 18 until the trust terminates, for argument's sake, at the age of 25, those beneficiaries, because now they are majors, they'll be able to receive the income themselves. And then when it terminates, they get the capital. But the emphasis, Maya, I think, you know, I'll emphasize it so many times. There must be liquidity in the estate. There must be cash. If you're leaving just a fixed property in the trust, means absolutely nothing, because that fixed property needs to be maintained. Those kids must still go to school. Food must still be on the table. Somebody needs to provide it. And the easiest way, I always say to people, the easiest way to create liquidity in an estate is through a life policy, a life cover.
And I want to ask you a little bit about that. Actually, this leads me on to this to my shock of the week, because my shock of the week was executive fees. So let's get to that point, because executive fees are another need for liquidity. So you've got to pay, sort of 3.5%, excluding that. So it's about 4%. Okay, that's the maximum. You can negotiate it down, and maybe we can discuss that. But suddenly those fees have to be paid as well. And so maybe first of all, I want to just make a comment about the life policy and whether or not to leave the life policy to the children or to the estate because of estate duty fees. Do you want to comment? I don't know which of you wants to comment on that.
Yeah, I can jump in there. Yes, it is true that if life insurance policies pay directly to a beneficiary, that it doesn't go through the estate, then you don't pay the executive's fees of 3.5%. But if your minor beneficiaries are, or if your beneficiaries are children, minors, and you haven't provided for a trust for them, then the money will have to flow through to the Department of Justice's Guardians Fund, because that's where monies accruing to a minor will have to go. So minors' inheritances go to the Master's Guardians Fund, which I'm not criticizing it at all. There's a system there and it works for many people, but preferably I would rather have said, okay, if you're going to leave your policies to a minor child, then rather stipulate either it goes to an inter vivos, a living trust for them, or set up a testamentary trust in your will. And yes, I accept the fact that there's now going to be an executor's fee levied on that money flowing through to the trustees. But at least now you have trustees that you can engage with while you're still alive. You can agree fees with them as well. And you know that the money is going to go to, say, a Sanlam Trust trustee and will be looked after and protected and managed, and a monthly income paid to the children, the rate will be the school fees. Whereas the money rests with the Guardians Fund, then it'll be up to the next of kin left behind to then approach the master from time to time for money. So it's really a personal choice. Yes, the fees are there. The trustees are going to charge an annual fee on the work that they do.
And so in terms of executive fees, so, testamentary trust aside, if you're just winding up my estate, so I looked at winding up my estate. So your house forms part of the estate. So you sort of think, well, I've got pension fund. By the way, pension fund assets don't form part of your estate for estate duty purpose, for executive fees purposes. Or executive fee purposes, but your property does, and a couple of other investments. If you're married in community of property, it's the entire estate of both spouses that gets included. So that fee can become quite significant. I mean, how negotiable is it? I mean, as if you are looking to negotiate that fee, I know I'm asking the guys to earn the fee, but how should you negotiate that fee to make sure it at least doesn't wipe your estate out, your estate's liquidity out? Should I put it that way?
Absolutely, yeah.
So is it?
Yeah, I'll jump in there. So I just wanted to go back a few steps back to the life policy that David explained. That let's say this life policy now flows into the estate. We've got, because we're creating liquidity in the estate using a life policy, we do have an opportunity of negotiating for the life cover proceeds. Those proceeds of the life cover, we can negotiate a discounted executor's fees on that with Sanlam. So we are able to offer that. The second point is, approaching your potential executor to negotiate a discount. It's something that can be done. And the executor obviously will look at the complexity of the estate. And the value of the estate. If the estate is complicated, there's farms, there's use of here, there's a whole lot of other things. They look at the complexity and then they can come up with an offer. So people mustn't be shy to actually go and knock and negotiate. We don't like giving out discounts willy-nilly, but we look at the complexity, because you also don't want to make negotiate for a discount that you, at the end of the day, you feel like, actually, we're doing this now for free. But definitely you can approach the potential executor and negotiate.
So that's a good tip. And that's another good reason to appoint an executor in your will and have that up front, so your family is not trying to deal with that, at a later stage. I see
recorded in the will,
that discount or whatever discussion that's happened is recorded in the will. So Petra has asked for a little bit more information on testamentary trust. So what I'm going to do is I'm going to put a pin in that and maybe get back to that in a little bit more detail towards the end. So Petra, I have seen that, and we will go into a little bit more explanation about how that works. But I wanted to ask a question that I've had a lot of questions on recently, and that is how your marriage contract affects your will. Because if, in South Africa, we have this major problem, and I think it's a problem, that your default marriage is in community of property. It has so many ramifications that people are not aware of, like not only that you own each other's debt. So any debt your partner takes on is your debt. But in your will, your estate, you're not free to give your estate to anybody you choose. So who would like to, David, maybe do you want to, Moremadi, maybe you want to pick this one up.
All right, let me jump in and I'll just touch on in community of property, and then I'll let David run with the other marital regimes. So in community of property, Maya, like you said, it is a problem. It is the default. And a lot of times I've seen that the only time, clients actually start engaging and understanding their marital regime is when the other spouse actually does not make sense to them anymore. When people are starting to have, funny vibes in their marriage, and you sit down and you explain to them, this is how you can actually structure your estate to protect your share. That's when people get an eye opener. It's like, oops, I didn't know that. The unfortunate part, if you are married in community of property, everything is in one pot. Meaning I said we've got freedom of testation in South Africa. So meaning, if you are married in community of property and you want to set up your own will, you can. However, there's always challenges around it being executable. I'll make an example. We've got people who are married in community of property, and the one person wants to bequeath half a share of a house to a cousin. How will that work? Is the cousin now going to come and live with your husband, or is the cousin going to buy out your husband? We get those dynamics, and we get it a lot of times. So that's
advice when you're writing up the will.
We get it a lot of times. And I think that is because people don't necessarily understand you're dealing with half a share. And when you're dealing with half a share, how practically possible is it that half a share will be distributed to someone else unless they can buy each other out? And that is the dynamic around in community of property. When I'm talking about in community of property, I also want to touch a little bit on customary marriages that have an in community of property default around them. And that also creates a little bit of a problem. I always say to people, if you are married in terms of customary marriage, it is advisable to go and register it. And if you can opt to register it out of community of property so that it doesn't default and go in terms of the civil in community of property. I think, David, you can jump in on the other marital regimes.
Well, actually, before we do that, maybe, David, you want to get on to that, but I wanted to ask you, maybe, David, this question. So this is a question I actually get quite often, is estranged partners. So one has left the marital home, they've exited the marriage from a day-to-day perspective, but they've never got divorced. What are the implications when one of them dies? So the person living in the house dies, or the person who's left that home dies, and then leaves their estate. There's a massive consequence to those. I think people, when they're estranged, don't realize in community property still keeps their estates bound.
Yes, absolutely. And I'm sure this happens a lot. So if you're still married, whether in terms of civil law or customary law, which is equally valid and binding, or in terms of the Civil Unions Act, which allows people of same sex to get married, and you decide to split, from a legal point of view, you are still married. And if you were married to that person in community of property, whether you've been living apart for a day or 10 years, it's the joint estate when you die. You're going to have to surrender, as the surviving spouse, you're going to have to surrender your assets into the deceased estate. It's a joint estate, and that estate will be wound up according to community of property. If you are married out of community of property, it may not be such a big problem unless you chose the accrual regime. So if you said, fine, we're getting married out of community, what's yours is yours, mine is mine, But from the day we are married until the termination of the marriage by death or divorce, that growth in the respective values of our estates will be equalized on termination of the marriage. So you may not have seen this person for 15 or 20 years. Then you're going to get a call from a lawyer, and you're going to think it's one of these bogus calls where you've inherited millions in some island somewhere off Bermuda. But actually, unfortunately, you were still married to this fellow. And the estate will be wound up accordingly. So you can't, it's a contract. Marriage is a contract. If you're going to break the contract, it's got to be done by a court order.
Mm-hmm. And I really, I think that the marriage aspect and not formally divorcing seems to be a big issue with wills. I've had a question from Molly about, does a pension fund form part of the will? And that actually leads me quite nicely, Molly, onto another question that I'd had in a bit earlier that I wanted to discuss, which relates to this what happens to kids in divorces. But, no, a pension fund doesn't form part of the will. And you can maybe address this in replying to this particular person who sent in this question. She said, my mom lives with her partner who is not my dad. And this partner is retired and he is dependent on my mother. They are not married. She, on the other hand, is still working and she has a pension fund. She has life cover and she has accumulated assets over the years. Who has more rights, me as the kid or him as the common law husband? David, maybe? I can see his face. He wants to take this one.
Yeah, good one. And firstly, we have no such thing as common law husband or wife. I mean, we live in a democracy. You can choose to live with someone and you don't have to be clothed with the obligations of marriage. So if you haven't chosen to get married with somebody, but you're just living with them, you're not actually married to them. But over the years, as you probably know, the rights of the live-in partner, the live-in partner have been advanced. Now, in this particular case, who's going to have more rights? Well, if a parent dies and they have a minor child, that child certainly, or a child who's dependent upon them, they certainly have a claim against the estate, and they certainly have a claim against their pension funds as well as a dependent. But equally, if you're living with someone and they've become financially dependent upon you, so for example, in this case, they could also look at putting in a claim in terms of the Pension Funds Act, but not in terms of the Maintenance of Surviving Spouses Act. Now, if you're not married to someone, you don't have a claim in terms of the Maintenance of Surviving Spouses Act. That's the law. Yes, the recent Buanya case in the Cape High Court 3 weeks ago may have turned all this on its head, but it's still got to be confirmed by the Constitutional Court. And I don't think the Constitutional Court is going to find that live-in partners have a claim in terms of the Maintenance of Surviving Spouses Act. I might be wrong, but it's certainly going to cause a lot of problems for people if it does.
So just to summarize, basically, in this scenario, there is no claim by this partner on the assets outside of the retirement fund, the rest of her estate. There isn't necessarily a maintenance claim on.
No, if however he dies intestate, then in terms of the Buanya case, where the court in the Cape High Court said recently that the fact that a person who lives with someone is not regarded as a spouse for intestacy and therefore cannot claim, they felt that was unconstitutional, but it's got to go to the Constitutional Court. But as things are at present, if a person dies without a will and they're living with someone, that person has got no claim at all against their estate. Living with someone gives you no rights. You could easy come, easy go. But if he had a will and he provided for her, so he said, look, I'm going to leave some of my assets to my live-in partner, my girlfriend or whatever, that would be a valid bequest. The actual wife can't object to that. A lot depends on how if she's married out of community property, then, that she not have any claim to the estate at all, particularly if she's not dependent anymore.
So, Moremadi, I'm going to put because this ties in with Molly's question. So, in this scenario, this partner who's a financial dependent does actually have a claim under the pension fund. So maybe explain why a pension fund isn't actually ruled by your will. So there's another whole layer of things that gets done when it comes to a pension fund.
Yeah. So, I always bring an emphasis on the acts that actually govern the two, scenarios. We've got the Wills Act and the Administration of Deceased Act being dealt with separately from the Pension Fund Act. The Pension Fund Act has its own rules. Hence, these monies, they're not coming into they're not flowing into one pot. And I always make an emphasis to people that when you're drawing up your will, we do get a lot of people that are confusing their assets to include the pension fund money. People would say, you know what, in my estate, I've got about 6 million, while at that point, that 6 million is sitting in GPF funds or in whatever your pension fund structure. And I always say to people, just be careful. It's two separate things. And how you deal with it two separate ways. So with the pension fund, what you need to nominate, you need to complete is a beneficiary nomination form. And the beneficiary nomination form, I always say to people, a lot of times, the first time you got the employment contract, that was probably the last time you completed that form. Try and keep it current. We've seen a lot of people who've passed away in the beneficiary nomination form. They had their mother as the beneficiary, while a couple of years later, they've moved on, they've got children, they've got a husband, and they didn't make it current. So I always say to people, when you're sitting down and you're doing your estate plan, you do your will, you draft it in terms of the Wills Act, you complete your beneficiary nomination form in terms of the Pension Fund Act. But I want to emphasize, Maya, that the nomination form, beneficiary nomination form, it is exactly that. It is a nomination. The trustees of the pension fund will use their discretion in terms of trying to figure out who actually is financially dependent on you. So we have a lot of scenarios where people maybe in terms of the beneficiary nomination form, they've selected whoever, while they have minor children as financial dependents or life partner as a financial dependent. The trustees will actually, use their discretion in that regard.
Which in this particular case, her live-in partner who's relying on her could go and make a claim on the pension fund. Her entire asset in the world to her daughter. So I think that's very key. And the other one that I'm getting a lot of, you see, the people who don't really trust their partners here, they're very worried that when they die, if they did what I've done and I've left my entire estate to my husband in good faith that he will take care of my sons and all the rest of it, some of them are worried that, it always seems to be women who worry this. They always think the husband's going to go and meet some 20 years younger than him and forget all about the kids. So is there a way to protect an inheritance for the children, going forward? Even if where they're minors or majors, how does one construct it so that that your children are going to be cared for, even if they still have a parent?
Yes.
David?
I'll jump in there. Yeah, as we said earlier, a testamentary trust is a trust you create or draft during your lifetime. It forms part of your will. There's no additional costs there. So you could actually stipulate in your will that you wish your assets to go to a testamentary trust for your children, but that your husband, for example, is entitled to an income from that testamentary trust, from the asset in that trust for his lifetime or until he remarries. You can even stipulate that if you wish to do that. Although I think that can also cause hardship for the children, and that can certainly end up splitting families. I don't necessarily think that's a good idea, but that's a personal choice. The other way, of course, is to settle your assets into a family trust, a discretionary trust, and give your trustees a discretion or give them an instruction to provide a certain income to your partner during that person's lifetime, but make it clear that the capital is only to devolve upon your children in the fullness of time at a certain age that you might stipulate. So you can certainly protect the inheritance. You can give, for example, usufruct over a property. So in other words, the partner can live there during their lifetime or until they remarry, but the house actually is bequeathed to the children. They are the owners of the children, but it's just burdened with this usufruct, with this person who's allowed to live in the house.
I do. Somebody's commented that it's also the men that worry about the wives not looking after the children. So
Yeah, I don't know.
It is an important part, and of course one can also use because one of the reasons you do tend to leave your entire estate to your spouse is because you don't have to pay then estate duty or capital gains tax on that.
Yes.
But you could take your first 3.5 million, which is not taxable in terms of estate duty, and leave that to your children in a testamentary trust, for example.
Yes.
So you could do that, ring fence that money, so at least you know that portion of it is available to the children and protected perhaps from your partner being blinded by love by the wicked stepmother or wicked stepfather.
I agree completely. Yeah. Absolutely. The question also arises, people sometimes ask you, well, should they appoint the spouse as a trustee? And once again, it comes up to a trust issue. I sometimes find people have set up inter vivos trust with the spouse as a trustee, but then they get divorced. And that's not a reason that the trustee should resign. So I think, when you set up these structures, just be if you're thinking this way already, then logically speaking, it would make sense that your trustees are going to be independent professional trustees who would look after your children. And they would engage with the husband, with the surviving spouse in terms of what his needs are over time. And I mean, that's something that we do all the time at Sanlam Trust.
And another interesting one that I've picked up as well, which I think is quite a good thing, is to also consider when you're writing up your will, if you are leaving money to children, and I'm talking now, unless could be adult children, you could be, 70s and you're writing up your will, is you can stipulate that inheritance remains out of the marriage regime. So it doesn't get caught in community property. Moremadi, how does that work?
So, a lot of trust companies, but I'll speak obviously on behalf of Sanlam. In our will, we actually put it as a standard clause. And that standard clause basically says, Maya, whatever happens, this inheritance will not form part of your marital regime. If you go and get married in community of property, this inheritance will be excluded. But I also want to emphasize, what that protection is about. It protects you against your spouse, not necessarily against now the debts that the in-community of property is going to accumulate. And that's where we just need to be very careful in terms of how we actually structure it.
Oh, that's interesting. So if the in-community is, if your spouse goes off and racks up a whole lot of debt, they could still claim against that inheritance.
Absolutely.
Okay.
I've had cases where, so the daughter might say inherit the farm, and it's stipulated that it's outside of the community estate, which means that it's not liable to be attached in terms of the divorce situation or in terms of marital law. But the problem was she was married in community of property. Husband was involved in a money lending business, was hopelessly bankrupted, insolvent, and the joint estate was insolvent, and the farm fell into the joint estate. That's once again there. It would have been better, with the benefit of hindsight, for him to have bequeathed that farm to, say, an inter vivos trust for his daughter, completely out of the clutches of the partner. So those clauses protect you in other words, between the parties, but it doesn't protect you if in terms of third party creditors of the joint estate, if that person's married in community of property. Yeah.
I'm going to ask just now a question that I also received through about when should one use a trust? But I have had a question coming in here, and I think this is important because we did allude to it just now. What are the tax implications when transferring these assets to a third party? So I'm not sure quite what they mean by transferring. I mean, we're talking about wills, so we're talking about obviously death duties here. So maybe just sum up, Moremadi, what are the, I mean, because there's quite a lot. It doesn't just stop with estate duty. There's a couple of implications. So if I had to leave my money not to my spouse, but to my children, what would the tax implications be?
So I think, we need to emphasize, there's been a lot of emphasis around executors' fees and masters' fees as the only fees that, are going to key in due to death. I say to people, dying is very expensive, actually, because you leave a whole lot and a lot of things become due and payable. One of the things that, besides estate duty and executors' fees, one of the things that happens is when we move assets from my name now to my beneficiary's name, there is transfer costs. those kick in and somebody needs to pay them. They're payable by the estate. So those are quite important as well. We get a lot of times where also people want to do, cash legacies, special bequests. Those become also due and payable. There's also, preferential claims like the maintenance claim, like the accrual claim. They also need to be paid because they become due and payable. So there's a whole lot of claims that kick in at that point in time. So on top of executors' fees, estate duty, your tax obligation, because some people think, I owe SARS and I disappear. When I die, SARS wants its money. So, there's quite a whole lot. There's CGT implications. So it is quite a lot. So dying is quite costly.
No, it is. And we just, people don't often realize that assets are deemed sold on your death. So even if the minute it's deemed, because the ownership is going to change, and that triggers capital gains tax. So you could have, where it's a house that you've left your now in an example where you're not married, for example, you're just living and you leave the house to your partner. There is capital gains implications and estate duty implications. Estate duty if it exceeds 3.5 million, but there could be capital gains implications. I know residential houses are slightly different, but there are all of these things that you have to consider, which I think comes back to the point we started off with was, absolutely just at least get a will in place. But if you have assets and you're doing more than just leaving it to your spouse, get advice. Look at how to plan so that you're not paying more than Caesar is due to Caesar. Don't pay Caesar more than is due to Caesar. So there are ways
absolutely. There are, and in your example, you're so right. Fortunately, the law does regard a live-in partner, life partner, as a spouse for estate duty purposes and capital gains tax purposes.
Yep.
So there won't be estate duty or capital gains tax if assets are going to your live-in partner from your estate. And of course, as you said earlier, there's no donations tax between spouses. But if during your lifetime you wish to transfer assets across to your children, for example, there can be taxes. The unfortunate thing is, whether you have a will or not, these taxes are the same. So you can say, well, I don't want to do a will. This is too much of a headache for me. But all these taxes and fees are going to apply. For example, you touched on fixed property. So there won't be transfer duty out of an estate, but there will be conveyancing fees, attorneys' transfer fees. So it is a bit cheaper disposing of property through an estate to an heir than it is, say, selling a property from one party to another, where there'd be transfer duty as well. But whether you die intestate or not, those properties have got to be transferred out of your name to your heirs, and so those costs are going to kick in, unfortunately.
I'm telling you, when you look at this, it's cheaper to get a will. I promise you, it is cheaper to get a will drawn up and pay for the advice than to die without all those things. That's my conclusion.
Some assets being transferred are very, very inexpensive, like vehicles, cash. There's no fee on that, or maybe process policy. Yeah. But fixed property can be expensive. But of course, as you said, if it's your primary residence, it's exempt from capital gains tax up to 2 million in any case.
So I do see somebody commenting that the cheapest way to die is to bequeath to the spouse, obviously using the statements, CG rollover, because it just explain to people listening what that means is if I die, I get 3.5 million rand tax free from I don't pay estate duty on my first 3.5 million, but if I transfer it all to my husband, on his death, he inherits that 3.5 million abatement. So on his death, it's 7 million before you start paying estate duty. So that's where it's quite simple at this stage, unless Dennis Davies has anything to do with it. There are talks about changing things, but at the moment, it is. If you have a spouse, it's the cheapest thing to do is you just let everything and you leave it to them and make it their problem. But you do then at least double up on that tax-free amount that you get out. But I want to come back to trusts, because we've had questions about trusts and where is a trust? We're talking about all these costs, estate duty and capital gains tax and all of this. Where is a trust appropriate?
Are you talking about a testamentary trust or an inter vivos trust?
An active trust. A testamentary trust is very different. It only is created on your death for your children. It is a a special trust that's taxed very differently.
Yes.
You don't pay normal taxes as you do on a trust. So that is, so let's not talk about that. Let's just say I today want to protect my assets from all these taxes. Is a trust as effective as it used to be?
Yes, a trust, an inter vivos trust, setting up an inter vivos trust can be very, very effective. As you alluded to, trusts do pay income tax, they do pay capital gains tax. So, one's got to bear that in mind. And the levels of capital gains tax and income tax in trust are very, very high, generally twice as much as the sort of average natural person. I think the advantage of trust is more about protection. Trusts aren't really, they're not going to save you income tax. They probably won't save you any capital gains tax. They will protect your assets, though, from creditors, from legal difficulties you might get into. It can also protect beneficiaries from themselves. So you set up a trust for people that are either minors or are unable to look after their own affairs. And we have trusts, that umbrella type trusts, that deal with that. But I think, when I first joined the industry many years ago, many trusts were not compliant. People were playing fast and loose. They weren't paying income tax. They weren't paying any capital gains tax. Those days are certainly gone. You've got to have an independent trustee. There's a lot more governance in place. So yes, I would definitely advocate trust for continuity, succession planning, protection of assets. Setting up a trust during your lifetime to, say, set up a nest egg for the education of your children and your grandchildren would be a fine idea, because, we don't know when we're going to die. If we die prematurely, we may not have had enough time to put those things in place. And now you have a trust in place, you've got professional trustees. Your passing won't really change the operation of the trust at all. The trust just carries on and looks after your legacy.
And I've seen that as well. I think trusts they are quite either expensive to maintain, and any time you do any transaction within that trust, if you sell a property or sell any shares, the taxes are there. I just feel that you can't get away from tax. You can construct it, you can try and be a little bit more, try and cut down on the tax. Pretty much impossible.
You can use them wisely. For example, you can, if you're using the conduit principle, if you distribute income or capital gains through to beneficiaries, you've got a lower tax return than the planner, and you put your resolutions in place, and then you can achieve tax reductions, legal tax savings in that way.
So we've had a question: is a trust better than a will? But a trust and a will are two very different things. That's not. You always have to have a will.
You always need a will. Because you're going to have something. All of us have a residue, and this is where it comes in. Often, why do I need a will? I don't own anything. We all have something. Whether it's the shoes on our feet, the watch on our wrist. So yes, you can set up a trust, and you put stuff in that trust while you're alive. But remember, to your particular call, it's a good question. I mean, I've actually had this question many times before. But at the moment of your death, whatever you still own, your last month's salary, your property, your any debts you have in your own name, accounts that you owe, pension monies that are going to accrue to you, still have an estate. Your trust is a separate legal personality almost. When you die, you've got an estate, and that estate has got to be wound up, and you're definitely going to have something in there that has to be wound up by law and transferred. So make sure you have a will. If you want to have an inter vivos trust as well, then that's absolutely fine. But those are separate processes.
Separate, I must tell you, we had a trust, a family trust, which I unwound because I just found it wasn't going to be of any benefit. I mean, and thank goodness we did that, because we did that. Remember, there was a time that you could do it before the new legislation came in. We sold our home in Johannesburg, moved to Cape Town. You know what we would have been paying on tax as a result? Would have been sitting in a trust. So I think those days of trusts protect you from tax, I agree, are very much over. Then I had a question. Can we touch on, have you dealt with wills where there are policies under a duly registered ANC or post-ANC recoverable okay, I'm assuming this is an antenuptial contract, not the political party, by a surviving spouse or child, which is excluded as deemed property in estate. This is somebody with a technical background. I can see a CFP, which is excluded as deemed property in estate duty tax. I found this is not commonly used or even known as a way to reduce estate duty. Can somebody say that to me in English?
Okay. Yeah. So policies that you agree to dispose of to your children or your spouse in your antenuptial contract will be exempt from estate duty on your demise. But I must say, I was a notary many years ago, and many friends of mine are, and you seldom ever see that in a notarized antenuptial contract. Maybe it's because when people get young, typically when they get married, they're quite young. They don't have any insurance, life insurance, or if they do have life insurance, it's been ceded to pay for debt. So you need to have that insurance to pay your mortgage bond off or your car. You don't necessarily have the luxury of saying, well, this money can go to my family. And the problem is, you need to do that before you get married. So you do your antenuptial contract before you get married, or it's got to be registered within 6 months or 3 months of your marriage. You can't do it later on unless you approach the High Court. So, it is something to bear in mind, but you've got to do it then right at the beginning.
Okay. And can we touch on estate freezing, please?
So I presume the person's talking about inter vivos trusts. I think that's where, for example, you have an estate that's growing and you want to make a use of the 100,000 tax-exempt donation that you can make every year. So instead of allowing your estate to grow and potentially your exposure to estate duty increasing, you and your spouse would make use of the 100,000 tax-exempt donations, so effectively 200,000 Rand. You could put into a trust, no tax implications. It's all quite legitimate. That money then grows in the trust. And of course, when you die, money that belongs to the trust is not part of your estate. Only if you have a loan account, a credit loan account in that trust would any part of that trust form part of your estate. I think that's typically what I used to understand as estate freezing when I was a legal consultant in the field. Yeah.
We are getting quite a lot of technical questions through, but I want to get back to the one about the testamentary trust. So maybe I will give it a little bit, so because we did talk about it, and maybe we need to just explain right at the beginning. So the testamentary trust is a trust that is formed on your death. It doesn't exist until you die. And it is there specifically to provide for minor children or children with special needs. That's actually quite important. If you have a child with special needs that may never, that you're concerned about going through life, you can create those testamentary trusts, and it becomes a trust, and it has the legal protections and all of those things of a trust. But you do have to have a trustee that then, makes sure that the money is paid to the guardian. So that is also separate. I mean, do you advise, Moremadi, that your guardian is separate from the trustee, or is only that you have a trustee that is separate from being just the guardian?
Yeah. So there's two separate, we're talking about two separate responsibilities here. And a lot of times people, when we're talking about a guardian, they think it's somebody who's going to be managing those finances. So when we're setting up a trust in terms of your will, a testamentary trust, you are nominating in that process, you are also nominating a trustee in terms of your will. So in your will, you will have nominated a trustee. So in this case, we can use Sanlam Trust to be the trustees of my estate for any trust that will be set up in terms of this will. So now in this case, it's a testamentary trust for minor beneficiaries. So what we'll do, you'll have a section where you've nominated a guardian. The guardian typically is somebody who's going to be living with those minor beneficiaries. And the guardian, in my example, I said the guardian is somebody who's going to receive the income until those minor beneficiaries get to the age of 18. And then the trustee does the actual, administration of a trust, the normal day-to-day. They make sure that, the monies are invested. Remember, the intention of the trust is to make sure that we preserve this money so that it looks after the minor children. So a trustee, if you give it to a layperson to run as a trustee, they might not necessarily be able to know what to do, because you need to invest this money, you need to protect it and preserve it so that it can last the children up until whatever the termination age is. So it's two separate things.
Yeah, absolutely. So that is it. And I mean, I have set, obviously I've got testamentary trusts in my will if something happens to my husband and I, and we've set that as age 25 because I think kids are probably only responsible by then. Rafilu has come back to this question about the trust and will, and it is, I have a residential property, a car, and a few investments. Should I have a trust? And I mean, my answer would be no, it's just not worth the complex. It's complex, it's expensive. David, what would you say?
Yeah, look, obviously it would be good for Rafiwe to engage with a financial planner. I think just tabletop advice, I would say probably not. It's great. She's got some nice assets and this, these are good. But I think she can protect those assets if she has children with a testamentary trust. Make sure that she has a will. If it comes to the day where, for example, she decides to buy a second property, rent it out. Let's say, for example, there's other factors. She gets married and she's getting married in a community of property and she doesn't want that property to be part of the joint estate. Then she might look at forming a trust and putting that property into a separate legal entity, the trust. So all depends on the personal factors. But remember, if you have a trust, the trustees must file an annual tax return. They are entitled to relatively small but annual fee for the work that they do. There's governance, resolutions that have to be put into place. You're going to have an annual general meeting. So if Rafiwe is quite happy to actually deal with those issues, and it depends. She might be the type of person that's really up for it, maybe an accountant or an actuary or engineer, much cleverer than lawyers. Maybe that's her thing. But I agree with you. I also know of people that have sold on the idea of trust and thought it was the magic one and solved all their problems, and it just created too many hassles. And once you start falling behind with your governance, you don't have an independent trustee, or one of the trustees died, and now you've got to get a new letter of authority, and you don't get around to that. You just start running into problems.
So I think
hand it over to a professional. But Rafiwe might be on the way up. She might be accumulating a nice big share portfolio.
But I think my concern, David, is that people go into trusts and then now, for example, she wants to sell the residential property. You lose that 2 million rand.
Capital gains.
Not, she says she's very confused. Go onto the Sanlam online wills thing, fill it in, and and people will help you come up with some decisions as to what's going to work. Because I think that's probably the best. We need to be wrapping up now. So I'm going to end off with a final question by Elton. Guys, everybody, this recording is going to be up on Facebook, and we will hopefully, if you want to post more questions, we'll get Sanlam Trust to answer them. Is it correct that once I am an owner of a property, a financial institution must be named as an executor or co-executor to avoid the property not getting transferred after I pass? No, that's not correct. No. You can have anyone as an executor.
You can nominate anyone as an executor, but of course the master has the discretion as to the master at the end of the day of the High Court is the person who actually appoints the executor. Generally speaking, unless the nominated executor is the spouse, the master would be very reluctant to appoint a lay person unless that lay person has the support and can provide proof that he or she is going to be assisted by an attorney or by a trust company.
And I think just to clarify there that possibly you do need to have a will, but the executor that you name in that will could be a family member who then in turn hires an attorney or whatever, a trust company.
They might have to put up security, a bond of security. The master might require them to put up a bond of security, which is not required from a trust company or an attorney. So preferably not a lay person. But going back to the question, no, in order for your property to be transferred to someone, you don't have to have a professional executor. And remember, you could appoint a lay person and they can, by power of attorney, appoint a third party like Sanlam Trust to do the actual work for them.
And negotiate the fees.
Definitely.
I thought I was just getting off. Somebody on LinkedIn has absolutely agreed that trusts only work for growth assets. They're not for personal use or primary residence. So there you go.
Good idea.
I think that's an answer. And I would certainly Yeah. Oh, I see. Okay, so I see a lot of people. Oh, you know what? Just by the way, we've had the Sanlam Trust guys answering these, except I see they've all done it on the private chat. So what
I just noticed that now, but they don't have access to the comment section, unfortunately.
Okay. So you know what I'm going to do is I will actually copy and paste this into the comment section.
Thank you.
So okay, guys. So I will do that. That was, of course, we would. So I'm not sure how long we've got before we get, because this is a Facebook Live, and Facebook Live has a lot of rules about how long we can stay on for. But I think we've got okay. Maybe we'll have to. You know what we'll do is I will have these and I will load them on the Facebook Live event afterwards. That
you can edit them. You know, as my colleagues say, they were just trying to help me to answer the questions. So you can decide. They're much smarter than me, so you can decide which ones you want to put on the.
I suddenly thought, wow, that private chat's getting very busy. That was So I think that we're going to wind that up now, unless we're getting any more questions specifically on. Now I'm getting all this. Any of the other questions that I think we pretty much have answered most of them, and I hope that we haven't made this too complicated. It is. I don't want it to, because I think when you get into the nitty gritty and people ask nitty gritty things, it starts sounding complicated.
I agree.
Summing up, both of you said up front, just go get a will. And you know what, there are online, Sanlam Trust has an free online trust application form. If they're picking up things like you've got children, you've got all these things, they will give you some advice. But rather than just leaving it to just be, to die interstate, to leave your family with this, your wishes not to be carried out, it's a really big issue. And I think if you are estranged from your spouse, there are a lot of things you need to be thinking about as well, because that's the question I'm getting a lot.
That is a big question. I get asked questions. Do we have to have a joint will? No, you can have a separate will if you're married. You don't have to have a joint will, and you don't have to tell anybody what's in your will. Just tell them where it is, or tell someone like your attorney, your accountant, or your best friend. Look, if something happens to me, my will is with Sanlam Trust or XYZ. I was asked that a lot this morning. What if I die and no one knows I've got a will? You have to tell someone where it is.
You really. That's quite important. And Moremadi, what is your just know this kind of thing?
I think since the beginning of this week, I've picked up that people are actually procrastinating on doing wills. If they are not procrastinating, they are hiding behind culture. If they are not hiding behind culture, they are hiding behind other myths like it's very expensive, it's for the wealthy. And I think with this information, I'm assuming, we've killed all those myths. We've actually even addressed that, it's better off, you are better off having drafted a will than, passing away interstate.
I must just actually comment on that. Something that a financial advisor was telling me that she struggles with is that you get the couple comes in to write a will. They've got children, and they can't agree on the guardian because she wants her mom and he wants his mom, and then they have an argument, and the will never gets written up. So rather just flip a coin, get it done, date it afterwards.
Absolutely. I mean, you don't want to leave a mess behind, but you know what? That's one thing I'll forgive you for. Put both names in there and let the family sort it out.
So I think that's really, really, very, very valuable. And I just really hope anybody listening here, if you don't have a will that you're running out right now or going online, whatever it is, and actually get one written up, because it's extremely important, and it's not expensive. It's often free. It's not expensive. Get it done, because it's actually going to save your estate, massively in the future. But I do think though, doing it as much as you can go, I suppose you can actually print one off the internet. It is worth following a process, even if it's through Sanlam Trust, to have people ticking boxes like in community of property. Sorry, you can't leave all your money to the SPCA because your spouse actually has a claim to it. So I think those are the nuances. But get advice. I promise you, it's not expensive. It's not like you're going to pay out a fortune of money. So thank you to both of you, and thank you for all of those.
Thank you, Maya.
And we will post.
Thank you, everybody.
For those of you who missed the beginning.
Thank you, Maya.
Thank you, Maya. Thank you, and to everybody for paying attention. Bye.